Tim Blankenship here, Divorce661 Daily Perspective, day in the life of an LDA. There you are, camera. Episode 39. How you guys doing today for this Monday, December 11th, 2023? I'm a legal document preparer. In LA County, handling divorces throughout California, doing my daily updates. A little education on clients' issues, paperwork we handle, little updates on the process, and then I kind of go over a couple of things. Today, we'll be talking about if you can legally kick out your spouse during a divorce, common mistakes to avoid in a divorce settlement, and how to find the right divorce attorney for you. As far as what we had going on today, 4 consultations, 5 new filed divorce cases, 4 were in LA County, 1 was in Orange County. All of those are e-filed, which is great. 3 new divorce judgment rejections we took over. I'll talk about those people having issues with judgments. They're all LA County cases. 1 was in downtown LA, 1 was in Pasadena. Oh, actually, 1 was in Alameda County. Alameda County gives folks a lot of problems. 2 approvals today. 2 of our clients had approvals from the court. Got those out to them. They are done. 2 judgments were e-filed. Those were LA County. We can e-file judgments in LA County, which is nice. 4 judgments mailed in Sacramento, San Bernardino, and 2 San Diego cases. We've had a lot of San Diego cases the last couple of weeks. One of the clients we took on today or this week were just a spouse whose husband had filed for divorce, and they're still living together. And she was saying that they were going to be amicable, and she hired me, and she said her husband had already filed, and that she didn't think he had an attorney, and there's some mistakes on the paperwork. The length of marriage had been shortened to just under 10 years, and she thought that was a little funny. Anyways, she hired me to get a response in because she was kind of on the fence of whether or not it was going to be amicable or not. And when she sent the paperwork over, it was definitely not going to be. Can you say probably definitely not going to be amicable because husband had an attorney, which means that through that consultation, they probably discussed shortening the length of marriage. They're trying to play a game with the long-term marriage and spouse support issues, I imagine. But, I talk about I don't normally file responses when I'm working with both spouses, but in this case, I had to recommend we do. Number 1, it didn't appear to be amicable. Husband had an attorney, and she only had 1 day left to get the response in. So we got that in and provided her corrected, updated data separation, which put them clearly over 10 years. That'll be, that's not things that we address. They'll come up at either trial or through their negotiations and settlement on the length and duration of spouse support. So one of the other cases I took on, a judgment reject, I told you was out of Pasadena. These were common mistakes. And this is not just to this one client, but this is on this one petition, one case. This was the issues. Why their petition was not valid. They did not put a data separation on the petition, did not mark terminate spouse support for either party, let alone herself or her spouse. Just left that totally blank, and it's a big issue. You guys keep leaving that blank. Marked there were no assets and debts, but then filed property declarations with the court. Totally confusing to the court. And most importantly, was trying to do a true default case, what we refer to as default without an agreement, when her spouse said they would sign off on the paperwork. So in this particular case, what I'm going to first try and do is, because she tried to submit her judgment on the own, it was rejected, but not for some of the reasons I would have thought. They're rejecting it because there was no agreement provided, even though she was telling the court there was. She's putting assets and debts on the settlement agreement that are not included on the petition. You can't do that when there's no agreement. But most importantly was not having the spouse participate who said they willingly would sign off. So one of the issues that can cause your judgment to get rejected is that spousal support box is not being marked on the petition as far as you wanting to terminate or reserve or whatever you're going to do, especially on a default without an agreement like she was doing. But they did not flag it. They basically said in the reject letter, if you're going to turn your judgment back in, mark reserved. We've had courts even say, no, you can't even mark reserved on your judgment because you didn't request it in the petition and you had to amend the petition. So in this case, we're always trying to test the system and see what we can get away with. I don't want to have to amend her petition if I don't have to. So we're going to get husband to sign the settlement agreement since they haven't rejected the judgment based on the fact that they did not put a date of separation on the petition and did not mark to terminate support. The court basically was saying, if we'll let you mark this. So we're going to give that a shot. So I did their settlement agreement. They're going to send it out, sign it, and then we'll submit it. And if it gets approved, great, we're done. I think there's a 10% chance they reject it now upon further review to see that it wasn't marked on the petition, the date of separation, especially as well as the spousal support issue. So we'll see how that plays out. Okay, so now we are going to talk about some big topics here. And I want to preface this by saying, this information I'm giving you is not considered to be legal advice. I do some research. I read blogs by attorneys that I'm able to then go over what they said in their blog posts. So I research these things. So it's not me just giving you this legal advice. And then what I like to do is go off of, from an amicable standpoint, after I go through these points, is to give an explanation of what that looks like in reality and working with us or going through an amicable divorce. But I thought this would be an interesting question to answer. Can you legally kick your spouse out during a divorce in California? So again, I'm not a lawyer. I'm just going to refer to my notes here, but I can provide some general information about divorce laws in California as I've researched them. In California, spouses have certain legal rights and responsibilities during a divorce, including property rights and the right to occupy the marital home. Here are some key points to consider based on my research, not legal advice. We had someone really upset with me on TikTok. I take these videos and I chop them up into little 10 or 12-second clips. So you don't get the full, like this will probably be a 2-minute discussion here. You get 15 or 10 seconds of it. And they're like, oh, you're giving legal advice. You're not an attorney. And I think what they don't realize the difference between legal advice and marketing. My videos are for marketing, not for legal purposes. Okay. Can you legally kick out your spouse during a divorce in California? Number one, I have 4 points here. No-fault divorce. California is a no-fault divorce state, which means that either spouse can file for divorce without having to prove that the other spouse did something wrong. It also means that the reason for the divorce typically do not affect issues like property division and spouse support. So that on that foundation, that basis there, that would mean no. At that point, you can't just technically kick out your spouse. But there are going to be some other points here that do come up. Number 2, residence rights. During the divorce process, both spouses typically have an equal right to live in the marital residence, regardless of who owns the property or whose name is on the lease or mortgage. This means that you generally cannot unilaterally kick your spouse out of the marital home without a court order. That court order being the next part. Number 3, temporary orders. If one spouse believes that living together during the divorce is untenable or unsafe, they can request a court order for temporary exclusive possession of the marital home. However, they would need to provide evidence to support this request, and it would ultimately be up to the court to decide. So 12 years ago-ish, when I worked for the courts and worked for a law firm, there would be claims of domestic violence and requests for exclusive use of the residence. I think half the time it would work. The other half they would not because they're displacing obviously one of the spouses. But it's on a case-by-case basis. Obviously, if you're trying to get your spouse out because of domestic violence or threats, or maybe just you guys being there will lead to domestic violence. I don't know if that would be enough rationale for a judge to have a move out order or provide exclusive use of the residence. I suppose it could be, depending on the context and what's going on. Number 4, restraining orders. If there are issues of domestic violence or harassment, a spouse may seek a restraining order that can require the other spouse to stay away from the marital home. I think sometimes people use these, maybe they make up a domestic violence incident. I don't want you guys to kill me upon me saying that, but I think you would agree that there are people that use this as a ploy, or maybe it's recommended by their attorney to, hey, if you can come up with something that we can kind of stretch the truth on, we can try and get exclusive use to get your spouse out of the house. Does that happen? I'm sure it does. And I don't want to downplay the domestic violence is real, obviously, so don't get mad at me there. But yeah, you can get spouses out. You can also see when I was a police officer, if there's an incident that occurs that we responded to, we can do what's called a TRO. It's a temporary restraining order based on the on the facts. If maybe there's a domestic violence, whether it's misdemeanor or felony, if we feel like they may return, we can fill out, like literally on the hood of the car, a temporary restraining order, and we basically call a judge and go over the facts with them. And even in the middle of the night, usually in the middle of the night, and they're on call, and they'll give us the approval for the TRO, and then they can then take that to go into court to get a regular, I don't know if it's called regular, but a regular restraining order that's more than just 72 hours, which I think it's been a long time since I've done that, but I think it just buys them some time to get that restraining order. So I think in reading this, just in layman's terms, I think the answer is in a regular divorce, no. But if there's something occurs that ends up with some type of temporary order or restraining order that provides for that, then yes. So there you go on if you can kick your spouse out. Number 2, I want to talk about 10 common mistakes to avoid in a divorce settlement. I got some good ones for you here. Divorce settlements in California can be complex, and making mistakes during the process can have lasting consequences. Here are some common mistakes to avoid when negotiating a divorce settlement in California. Number 1, not seeking legal counsel. One of the most significant mistakes you can make is not consulting with an experienced family law attorney. An attorney can help you understand your rights, navigate the legal system, and ensure that your interests are protected. So that's all fine and well, but I think that while doing that is great, I would say 99% of my clients don't do that. I think that most people can go through an amicable divorce and know that where it's a community property state and everything's divided equally and so forth. I just had a consultation with both spouses maybe 30 minutes ago. And I think, so it sounded like the wife had consulted with an attorney, the husband didn't. So she knew a little bit more. So there's no harm, even if you guys are going to be amicable, to go out and have a consultation with an attorney, spend 30 minutes or an hour and have them read you the list of your rights so you can make informed decisions. And then that doesn't mean you have to hire the attorney. So now you have the power of information, and now going in to discuss with your spouse to make informed decisions because you know how the game plan is. It also helps people from making mistakes in arguing or fighting over things that are pretty black and white. Like if I've heard people say, Tim, I want 100% of my pension and I don't want my wife to have it. Well, that's just not going to happen. You can spend as much money on attorneys you want, and that's pretty clear cut, the community property division and so forth. So it can help you prevent you from making mistakes in arguing over things that are going to happen regardless if you have an expensive attorney or not. Number 2, failing to disclose all assets and debts. Full financial disclosure is essential in divorce proceedings. Hiding assets or debts can lead to serious legal consequences. Be honest and thorough when providing financial information to your attorney and the court. Yeah, you do definitely want to disclose everything. I talked about this last week. We don't see that as an issue here. Mostly what people are doing is they're so amicable that they're asking me, Tim, do we even have to list our assets and debts? And I always tell people, look, I'm not the divorce police. I don't know what you guys have. I don't know what the court has, but here's the disclosure form, from the court that says, you're supposed to do this. But the other downside to that is the misunderstanding of community property. In another consultation I had today, for example, I said, is there any assets and debts, 401ks or pensions or anything like that? And he says, nothing together. And this is a common phrase I get. No, we don't have anything together. And I said, I understand, but are there any pensions or 401ks and so forth? They said, oh yeah, we both have 401k and this and that. So those are still community property assets. They're acquired during the marriage. The fact that you're contributing to them during the marriage makes them community property, regardless that they're not on the plan. I mean, the beneficiary, it doesn't count. That's not what we're talking about here. But the fact that it's just been acquired during the marriage. If you just Google, so I'm not giving you legal advice, California community property laws. There's plenty of blog posts out there written by attorneys that explain this. It's pretty straightforward. But yeah, I think most of ours is not people, and I know they're not people hiding assets. They're just saying, is it really necessary to list them? We're both aware of what we have. Do we need to put it on the settlement agreement? Like I said, not the divorce police, but I tell folks, look, you need to include what you want to see on your settlement agreement that you are going to sign, that your spouse is going to sign, that the judge is going to sign, and then thus become a court order. And so if there's any dispute 5, 10, 20 years down the road, maybe someone falls on hard times and says, you know what, we never did discuss the 401k because it's not on the settlement agreement, and they want to reopen the case. And there's probably a good likelihood that would happen because it doesn't say spouse is keeping 100% of it. It's just totally left blank, and not addressed at all. Probably, I'm sure you could find an attorney who could get the case reopened and relitigate that and say, look, this wasn't addressed, and now we're going to address it 20 years later. So it'd be good to get that documented properly, I think. Number 3, ignoring tax consequences. Failing to consider the tax implications of your divorce settlement can result in financial surprises down the road. Consult with a financial advisor or tax professional to understand how different assets and support payments may affect your tax liability. I think one of the things that we're seeing a lot of these days is people using their 401ks as a buyout for the family home. And someone, part of the consultation I had with these folks earlier today was exactly that. And a lot of it is being drafted into settlement agreements that their clients are wanting. In fact, we're doing also a quadro for a past client who are modifying their terms, and they're going to do that exact same thing. And so you want to check with a tax professional on what that looks like to you, because if you sell a home and you guys take those proceeds, and that's not tax, it's liquid cash. And let's say you guys walk away with $100,000 each that's now in your bank account, that's not being taxed, versus in this scenario, let's say your spouse says, I'm going to give you an extra $100,000 for my 401k. We go through the quadro, they move that money over into a 401k on your behalf. Now, when you pull that money out, is that going to be taxed? It is a pre-tax investment. So I would imagine there would be some taxes on that and perhaps some penalties. Again, do your own due diligence, but I think that's what we're talking about in this number 3, ignoring tax consequences. It might not always be apples to apples. So make sure you're having your paperwork looked at to make sure there's no issues for you. Number 4, overlooking marital debts. In California, community property laws apply, which means that both spouses are generally responsible for debts incurred during the marriage. Make sure to address the division of debts in your settlement. So you have assets on one side, you have debts on the other. Of course, you want to include those. Same question comes up, Tim, do we have to list them? It's not, we have a lot of clients who people did not really commingle their assets. They kind of kept them separate. And I'm talking short-term and long-term marriages where they had their own credit cards, they had their own income, they kind of mutually shared the mortgage. They'd each contribute either a percentage based on their income differences, or each pay 50% into a mortgage fund or whatnot. But everything else was separate. Maybe someone paid the electric, gas, and utilities, and the other one paid the TV and whatever other there are. And then their own credit cards, they had those on the side. They bought what they bought, and they just want to separate them because they feel that they're separate. You can do that. It's still technically community property, both the assets and debts. But if people want to simply keep what they have, we do that all the time, even when it's not kept separate. Not, they have joint cards, but it's like in her name or his name or whatnot. We still have folks saying, well, that's my debts, even though, I know I ran it up $30,000 and technically I could, get an attorney and, put half on him or her, but I'm not going to do that because these were kind of trips I took separately with girlfriends or whatnot. And so the court will not interfere with you guys dividing that up. If you guys want to keep 100% of your own asset or debt, the court, as long as you guys agree to that, it'll be totally fine. The court will not interfere. Number 5, rushing the process. Divorce can be emotionally challenging, but rushing to settle without careful consideration can lead to regret later. Take the time to understand your options, negotiate, and make informed decisions. So what I would say to that is most people that work with us, they've come to a point where they are rational, not making emotional decisions because they're amicable enough to sit down and work out and hash out their details and terms and then provide those to me so I can, get their paperwork done and draft their settlement agreement. I know that not often, but we'll get calls where I can hear on the phone that the wife is obviously upset, maybe even sometimes, on the verge of tears or even crying. And they're like, I just want out of the divorce. I want out of the marriage. I'm not working, but I don't want spouse support. I don't want child support. I just want my kids and I want to be left alone. And, obviously those are not great financial decisions when obviously there's a need for child support and spouse support, but I get where they're coming from. They're just so fed up. They're done. I think long term, that's going to fall under this category of making an emotional decision that is not in your best interest or even your children's in that case. So, but we don't get that here. Excuse me. Our clients are rational, amicable at various levels. And, I think what helps too is we're not sitting in a room together. So there's not an emotional charge. A lot of our clients are still living together. So obviously that is going to take a certain amount of you being amicable to continue living together through the divorce process. But those that aren't, that maybe, it's not the greatest. I mean, it's still divorce, but we do use a portal for the communication. So it doesn't have to be sitting in a room or a three-way call. It's communication through a secure portal where all communication is seen by all parties, so everyone's on the same page throughout the entire process. Number 6, focusing solely on short-term gains. Consider the long-term implications of your divorce settlement, especially if it involves child custody, spouse support, or the division of retirement accounts. What may seem like a win in the short term may not be sustainable over time. So I think what that could refer to is maybe you walking away from your spouse's retirement accounts, that maybe things are great now, and you're like, I don't want, here's how this comes across. He or she earned that working. I think it's theirs. I think they should keep that here at all time. And that's fine. We'll draft it up. Husband or wife is keeping 100% of their own 401k or pension, and the other spouse is knowingly and willingly, walking away from it. They're not being duped. They see it clearly on the settlement agreement. And the terms that they provide me, that's what they want to do. That's fine. Will they regret that 20 or 30 years from now? Who knows? But I think that's what this is talking about. That number one, I was talking about earlier, how maybe you just want to get out of the situation. So you like, just keep this. Maybe you don't want the fight. Maybe you don't want to have to, like he or she is, insistent on this, and I don't want to spend 30 grand on an attorney fighting for this. So I just I can go out and earn my own money, get my own pension or 401k. Great. I think this, focusing on the short term can be a mistake, but that's not for me to say. It's not for the courts to say. What the terms that you guys come up with is what I'm going to document, and I'm not going to question it. I'm assuming you have done your due diligence and understand that you know exactly what you're walking away from, because you'll see it on paper when you go to notarize your settlement agreement that spouse is keeping all this, you're keeping all that, and you'll know what you're getting and what you're not. Number 7, disregarding child custody and support. If you have children, their well-being should be a top priority. Work with your attorney to create a parenting plan that considers the best interest of your children and addresses custody and support matters. So child custody and child support has to be addressed as part of an overall divorce case. Some clients will say they don't want child support, quite a few, in fact. Some say they don't want custody orders, quite a few, in fact. It's because they're that amicable. Maybe they've been still living together and they're co-parenting just fine. Maybe they've been living apart for years and co-parenting just fine. When that happens, we still have to have a child custody and child support plan. But in the child custody, all we're saying is joint legal, joint physical, and that's it. It allows them the freedom to work out the terms on an ongoing basis and just as they have been while they're married, and maybe post separation, still being able to work that out. You don't need an official order spelling out all the dates and times. I think people are not shocked, but surprised to hear that we don't have to have a detailed parenting plan when it comes to custody. We just don't. And often, I'd say 99% of the time, we're not. It's very, very plain joint legal physical custody. Child support, still need to have address the child support. We just can't say, not address it. So we still attach a child support order to your settlement agreement that says that either there is child support or there isn't. If so, how much and when is it paid, etc. And so we can reserve it now. The courts sent me some different language, probably been 8-10 months now, that said we don't have to do a non-guideline child support order where we say here's the incomes and it says child support should be 800, but we want 0. That's the way we did it before. Now all we have to do is not even provide incomes of the parents. We just put that it's going to be reserved for future determination, and the courts are totally fine with that. So we've been doing that quite a bit as well. I think it's just important to note child custody and child support needs to be addressed. To what degree is up to you guys. Number 8, agreeing to unreasonable terms. Don't let pressure, or emotions lead you into accepting an unfair settlement, negotiate for terms that you believe are reasonable and equitable based on your circumstances. So that kind of goes back to the other point we were talking about, making, focusing solely on short-term games, walking away from, unreasonable agreements, or accepting unreasonable terms. I think you'll know what you're signing off on. We're, talking earlier about making the decisions just because you want the divorce to be over. Again, that doesn't happen with what we do. You guys are calling the shots, but I know when I worked for a law firm, I'd hear clients coming in and overhear them saying, look, they don't want to continue with the litigation. They just want to be done. And in that case, I think that you get grinded down, and attorneys are saying, hey, we can still win this for you, if you will, as a word. But I get that some people just get grinded down and they just want to give in, and that's going to be your call in that. But to negotiate terms that you believe are reasonable and equitable doesn't always mean 50-50. I talked about folks who client that wanted to keep the house. It was more important to her because of the 4 kids than having husband's pension. The pension was her community property share in the pension was more valuable than the house equity, but she agreed that she was willing to walk away with that because it was more equitable for her and reasonable because of the other conditions that existed, her having the 4 kids and really wanting to keep them in the family home. So there is a reason you may want to give and take a little bit more. It's not all about the dollar. Number 10, not documenting agreements. Ensure that all agreements reached during the divorce process are properly documented and incorporated into the final divorce. Decree, oral agreements, or informal arrangements may not be enforceable. And then obviously, I mean, you're talking about a different area of law. You're talking about what do you call it? It would be civil. You have an agreement, contract law, I suppose. But it is good to document. Like I said, I'm not the divorce police. I don't tell you what you need to put on there or don't. There's plenty of literature out there written by attorneys and the courts and the law as far as the disclosure process and what you should list, and community and separate property and all that. And we do document all that. I get that you're completely amicable, and I give people the choice. Say, look, I don't know what you have. Put down what you feel is important, maybe high value assets. Technically, you should be listing everything, and we will list everything if you provide it to me. But again, I don't know what you guys have, and again, I think the road people go down is some of our clients are so amicable that they're like, Tim, we don't want to list anything for a variety of reasons, because they are so amicable, possibly, and they know they're never going to have a dispute in the future. Or some don't want to list it because they don't want their assets and debts, with the possibility of someone acquiring that, because it is quote unquote technically public record. If someone knew about your divorce, could they go and get a copy of it? Sure, it's not published online or anything, but they could, go to the court technically and go down and get that. Okay, so that was, what were we talking about here? The 10 common mistakes to avoid in a divorce settlement. I think that those points all made sense to me. How about you? Now we're going to talk about 5 tips on how to find the right divorce attorney for you. Because not all divorce attorneys are made equally. Finding the right divorce attorney is crucial to navigating the divorce process successfully. Here are 5 tips to help you find the right divorce attorney for your needs. Number 1, research and interview multiple attorneys. I think that makes sense. Don't settle for the first attorney you come across. Research and interview several attorneys to find the one who aligns with your goals and communication style. Ask friends, family members, or colleagues for referrals and read online reviews. I think that's all goes without saying. Getting referrals. I think it's good to do all your due diligence you can in research online, and then maybe, I don't know, interview 2 or 3 of them. I mean, we all, there's people we like and don't like how they look, don't like what they say or how they said it, maybe their approach to it, maybe with the information, they just rub you the wrong way. Use your gut feeling and then back it up with the facts that you have regarding your research you did in reviews and so forth. Number 2, look for experience in family law. Don't settle for the first attorney you come up. Where are we at? Choose an attorney who specializes in family law or divorce cases. Experience in this area of law is essential for understanding the nuances of divorce proceedings. I think one thing I could add to that is the specialization part in family law, because I think a lot of attorneys may do, say, corporate law or business law or anything other than family law, and then they will also do family law as well. Does that make sense? Meaning, I think there's a lot of money to be made in family law because there's so many darn divorce cases going on. So it's kind of, they'll do that on the side, but their main litigation or is I don't know, auto accidents or something like that. So make sure it's their primary focus or specialty, and there are additional levels of specialty within the family law attorney realm. I think it's called, I've seen the initials on the back end. I think there's a class or additional training in family law. I think it's CLFS. So what would that stand for? I don't know. Certified family law specialist. That sounds good. That might be it. Don't quote me. But I think they have additional expertise in family law if they have that heading. Number 3, consider compatibility and communication. A strong attorney-client relationship is crucial. Look for an attorney with whom you feel comfortable and can communicate openly. During the initial consultation, assess their listening skills, responsiveness, and willingness to address your concerns. I think it's important that communication be there because you want to be able to relay to them what you want out of this process versus them telling you what they can get for you. And if they're not hearing you and they're relating something completely different to the opposing counsel, or if your spouse doesn't have an attorney, they're communicating with them, and the message is getting skewed from what you said by the time you get to them. What was that movie? Fast Times at Ridgemont High. Jeff Spicoli, called him the D word. And by the time it got back around through the school, I think they said he had stabbed him. So you got to make sure that you're duplicating properly the information you're telling your attorney, which goes into number 4, assessing their approach. Discuss the attorney's approach to divorce cases. Some attorneys may prioritize amicable settlements and mediation, while others may be more aggressive in litigation. Choose an attorney whose approach aligns with your preferences and objectives for the divorce process. And this is critical because I've been doing this 12 years, and prior to that, worked for a law firm, worked for the courts. And I know, at least in my local area, who the aggressive attorneys are, who the ones are more mediated or amicable settlements and more of a collaborative approach. And to the point where if, say I have a consultation with someone and I can tell it's not amicable at all. And I'll say, look, you're going to need an attorney because of X, Y, and Z issues you brought up on this call. I'll say, now, based on this, I think, I can give a personal recommendation to an attorney because I know how that attorney is. Meaning, if someone's canceling, locking doors on you, or removing the car, taking you off of title, taking you off of health insurance, closing bank accounts, doing all this crazy stuff, I think you're going to need an aggressive attorney. You don't need a collaborative attorney at that point. So I know who those ones are. To the other end of that, if you guys are amicable-ish, but you're not in agreement and you need someone to represent you, you may not be going to trial, but you need someone to represent your best interest, I think a collaborative attorney would be best in those situations. Obviously, what happens if you were like, you just need a little bit of legal advice and you need someone to represent you and just handle your affairs for you because you guys can't do it together? If you had the aggressive attorney, maybe you guys end up going to trial for issues that you didn't even have until you had the attorney. And I've heard that come up where they said, Tim, we were amicable. We hired an attorney because we didn't know there's like services like mine that are more collaborative. And we were in agreement. And then it turned out that the attorney said something or did something without me knowing about it. And next thing you know, we're no longer in agreement and we're fighting. And now he has an attorney. Now we both have attorneys and we're going to court. And prior to having the attorney, we were fine. And that does happen. So watch out for that. And that kind of goes back to, 1, 2, and 3 that we discussed about making sure they're a good fit for you. Number 5, evaluate fees and costs. Be clear about the attorney's fee structure from the beginning. Understand how they bill for their services, hourly rates, retainer fees, and any other additional costs. Ask about potential expenses and estimated costs, total costs of your divorce. I could probably do a full 30-minute video on this topic, and maybe I will, because you really need to read those retainer agreements. I would not, you know, you're going to be talking to 3 attorneys anyways. Let's say you're going through the motions and you're taking all of my advice and advice that I've researched of what you should do, and you do all the due diligence, you do the checks, you do the review, check the reviews, you do all that, you do 3 consultations perhaps, and then you're going to select the best one. Then you can sign the retainer agreement. I don't think you necessarily need to sign the agreement in the office. Take it back, read it. You're going to have the attorney looking over your shoulder while you're reading, 4, 6, 8, 10-page retainer agreement. And what a lot of people miss is this evergreen clause in there that basically says, your initial retainer is not the total fee. And once we go over the retainer fee, we can continue to bill you. And I'm saying this very basically, but they can just continue billing you and go over and not have to notify you. And then you'll be responsible for any additional attorney's fees. That's all seems reasonable, except for you don't know, you're not getting checked in with how much that bill is accruing beyond your initial retainer. So definitely read that. I mentioned last week, I had a guy we've already finished his divorce, already did their paperwork, and he was called 10 to 15. This is his words. I called 10 to 15 attorneys on the phone trying to, saying we're amicable. Can you finalize our divorce? And all that he kept hearing repeatedly was, my retainer is $3,500. My retainer is $5,000. Whatever the retainer was. And I don't know if that'll be your total fee because I charge X amount, hundreds of dollars an hour. And if I go over, and you'll owe the difference. I cannot tell you what your total cost will be. Crazy. $800. I did their paperwork, and they were being asked for between $3,500 and $5,000 retainers for an amicable divorce. So I don't know why it took them 10 or 15 attorneys to find me for. My God, I do so many videos, so many blog posts, so many podcasts, TikTok, YouTube, uh, all of it. And I know I'm not going to get in front of everyone's eyes, but I do my best to do that. But you definitely want, I know, having worked for a law firm in the past, the legal fees can quickly spiral out of control. So I'll close with this. Additionally, consider consulting with multiple attorneys before making your final decision. Many attorneys offer initial consultations, which can be an opportunity to discuss your case, get a sense of their approach, and ask questions about their fees and experience. By taking the time to research, interview, and evaluate potential attorneys, you can increase the likelihood of finding the right one to guide you through your divorce process effectively. Also, I want to add one last thing. Most attorneys charge a fee for a consultation, and I think you kind of get what you pay for. They usually will do a reduced rate. Maybe it's half of their normal hourly rate for that hour, half hour consultation. Some will do a free consultation. I say you get what you pay for, because if you're going to go ask for legal advice and interview them and all that, it might be worth going to an attorney who charges a retainer, charges a fee for the consultation, because then they're not going to spend it trying to sell you on how great they are in using their service, because they know that this is a 30 minutes of basically a waste of their time if you walk out the door. Or maybe they use that 30 minutes somewhat asking your questions. I've heard this happen. They say, "Tim, I went on this consultation. It was a free consultation, but it really felt like a sales pitch. Gave me a little bit of the information, but not enough, like forcing me to have to hire them before they'd give me any real legal advice." Not all attorneys do that. I know there's some good attorneys out there that do not charge for consultations. I think it's not a full, I think they're doing an assessment, like, what do you have going on? Let me give you some basic legal advice. But if you really need, like, you're having issues, you have legal advice, pay for that hour. And then now I don't say they're working for you, but they are. They're not going to, if it's a $300 for an hour consultation, use that time wisely. Go in with a legal pad with your questions. Have done some due diligence research online. Learn about the community property rights. You're not wasting time with basic questions. You want to make it specific to your situation. What's going on? What's your spouse doing or not doing? And get specific answers to your specific issues that you have going on, having already kind of gotten a basic idea of how the process works. Well, I hope you enjoyed Daily Perspective, episode 39, Day in the Life of an LDA. This was not legal advice. I'm going to close with that. Anyways, we'll talk to you tomorrow. I hope you guys are enjoying these and all the subsequent videos that come from them. Have a great day.